WPSL
The
St. Lucie.
opinions on this program are those of the program host and guest and not necessarily those of WPSL. WPSL does not endorse products that may be mentioned. Any reproduction or retransmission of this broadcast is strictly prohibited without written consent of WPSL. Legal questions? Ask a lawyer. Give us a call at 340-1590, 340-1590 here at the studios of WPSL. And Ask a Lawyer with your host, attorney Stuart M. Address.
Good morning, Treasure Coast. I'm Stuart Address, and this is Ask a Lawyer for Friday, June 8th. To all of you parents out there of students in the St. Lucie County Schools, congratulations. You survived 1 week of summer vacation. Whether your kids are at home, at camp, at grandma's, or wherever else they are, you've made it a week and now you only have another 10 to go. Good luck. I got mine right next to me, actually, my 14-year-old who just graduated 8th grade at Lincoln Park Academy. And he's been home this first week, so it's been a challenge. And now I'm trying to figure out what to do with him. My goodness, I don't want him home the whole summer. All right. Well, last week we had a lively discussion with a number of callers, and that is always the way I prefer it. My sort of bullet points of what I want to discuss every week, I'm happy to toss up, throw away, rip it up. Much rather hear from you and try to answer any questions you might have. So if you do, give us a call at 340-1590. Until that happens, we were talking and we finished up last week about mediation and what it is and what you could expect. So let me just take a brief few moments to sort of contrast mediation to arbitration, because they often get confused by those who are not really involved in the legal field or having legal issues, and all of a sudden you find out, you go to a lawyer and you find out you signed a contract and it has an arbitration clause. It's like, what the heck is that? Mm-hmm. Well, it's definitely not mediation, I'll tell you that much. Arbitration is like going to trial in court, but it's binding. Now, what are the advantages of arbitration? There are a few. Arbitration gets over much, much quicker than the average circuit court case, or federal court case, actually. Instead of it being 1.5 to 3 years, arbitration could be over within 6 months, sometimes less. So that is definitely an advantage. In arbitration, the rules of evidence in terms of what is admissible, what is hearsay, things like that, they're relaxed. The arbitrator doesn't really have to follow the rules of evidence or civil procedure. And that could be good or bad. But it's another distinction in arbitration. Now, in arbitration, one of the real drawbacks, at least for most of my clients who are plaintiffs, is that when the defendant, usually an employer or corporation, says, you signed an arbitration clause, you got to go to arbitration, you're not in court. The problem here is that you do not get the opportunity to engage in anywhere near as much discovery in an arbitration proceeding as you do in court. In court, you have things called interrogatories, which are written questions to be answered under oath. There are requests for production of documents. There are things called requests for admissions, where you ask the other side to admit certain facts. There are depositions, obviously. Anybody who's been watching the news now knows what depositions are. And obviously that all leads to a trial. In an arbitration, the only discovery which is permissible is that which the arbitrator decides to permit. So any discovery you want to engage in, you have to file a motion for permission to conduct it. Some arbitrators are very liberal, and some are very conservative because they want to get it over with, which is consistent with one of the benefits of arbitration. So if you are the party that needs information from the other side to prove your case, that's usually a plaintiff against a corporation that has all these documents. Arbitration can be a disadvantage because you may not have the same access and opportunity to get those materials and depose all those people that you want to depose. On the other hand, let's reverse it for a second, because I do represent sometimes small businesses or sometimes individuals who actually have virtually all the information they need. And so we wouldn't need much discovery. In those situations, that exact same problem that I've just discussed is an advantage. Because now, instead of us being stuck for 2-3 years in the crowded circuit court or federal court, which is just as crowded, if not more, we can go to arbitration and basically prove our case real quick. And that means less legal fees to my client. It means getting the matter resolved much quicker. It means having the whole thing over with and the emotional burden that comes with any legal proceeding past you. So there are definite advantages and disadvantages of arbitration. Now, arbitration is usually conducted before either a single arbitrator, just like a judge, or a panel of 3, especially if you're using the American Arbitration Association, which is in most arbitration agreements. Unless a panel of 3 has been selected, in the contract, the employment agreement, whatever it is that you may have signed, the presumption we start out with is that it's a single arbitrator panel. Honestly, I don't like it. I don't like the decision typically being left to one person who I really don't know at this point. I mean, I may have read a biography, but I don't really know. I would much rather have a panel of 3 where my obligation is simply to try to persuade 2 of them. So if you got some recalcitrant arbitrator who has a bone to pick or has a life experience that predisposes him to be against the client, sort of like a juror that you'd like to kick off in voir dire, then I can still work on the other 2. So in situations where it's not a mandatory single arbitrator, I always suggest to my client to allow me to file for the 3 arbitrator panel. And what happens is we would pick an arbitrator, the other side would pick an arbitrator, and then those 2 arbitrators pick the third on their own.
Oh, that's interesting.
So you sort of, they're all 3 are really impartial, but, when I'm picking an arbitrator, I'm trying to pick somebody who I really think is going to be disposed to my client.
Mm-hmm.
And of course, the other side is doing the exact same thing. If they've had experience with this particular arbitrator and usually rules in their favor, guess what? He's going to get tapped. But the 2 of them typically take the obligation to pick the third arbitrator quite seriously. And the one that is selected is usually somebody who really has experience in the subject matter that we're dealing with and is truly impartial. And sometimes is able to persuade 1 or 2 of the other ones to come along with him or her. So that is really arbitration. And as I said, it is dramatically different than mediation, because mediation, first of all, is voluntary. Second of all, nothing is concluded at mediation unless you want it concluded and the other side wants it concluded. Nobody tells you what to do. A mediator helps facilitate, an arbitrator decides.
Now, who are the arbitrators? Because you said mediators are attorneys who have to qualify to be mediators.
They wear black cloaked robes and masks. No, I'm just kidding. Arbitrators, just like mediators, are people who have gone to a number of classes, who have trained with an arbitrator.
But they're not like retired judges or...
Very often, yes.
Okay.
Very often retired judges, retired attorneys. There are lay arbitrators, and by lay I mean not familiar at the legal field.
Okay.
They may be business people, and that can be very effective in the right case.
But would they have to be then knowledgeable in the topic of the case?
Yes.
Okay.
I mean, otherwise they're probably not going to get picked.
Okay.
And then you have to be certified, just like mediators. You have to be certified as an arbitrator. If you're going to do American Arbitration Association, they have to certify you, etc.
Okay.
All right, we have Steve on line 1. Steve, hi. How can I help you?
How you doing? This is about an accident. I don't know if you can help me with this. Or if you
I can
cover
try.
anything.
I'm not really a personal injury attorney, but sometimes I play one on radio.
Yeah. Okay. I had an accident about a little over a year ago in the hospital. Okay.
Okay?
I was in there I had a heart problem. They rushed me to the hospital. I was there for about 4 or 5 days. I was trying to get somebody to get me out of bed because I had one of those things on me that goes off the alarm.
Right, exactly.
I kept beeping and beeping and beeping. Nobody came. I don't want to feel over myself more or less. That's what. So I got out of the bed. I went to the bed. I slept going into the bathroom. I hit the sink, busted my ribs on my back, blackened my foot, knocked a nail hanging off my toe. And I was, my whole back down, all blackened, little bad. I lay on the floor yelling for somebody to come and get me. I pulled the cord on the wall.
Right.
Nobody came. Somebody was passing by. They heard me. They came in, and he called for somebody. Somebody finally came. And there was only one person there that could take me down to x-rays.
Right.
I'm not a small person. This was a little person. It was just a whole bunch of junk, you know what I mean? I don't know if it's worth being bothered doing anything about this. Or
Well, let me ask you a couple questions.
I never got better since then. Never. Really.
All right, let me ask you a couple questions. I'm not so really, I wouldn't be so concerned as an attorney that they sent a
Right.
small person to get you. Small people sometimes have a lot of strength and they're trained. But
Right.
whatever your injuries were after they determined them, first of all, did they treat them?
They treated him? Yeah, I was let go in the hospital the day after, 2 days after.
All right, and you say it's about a year ago. You
A little
still
over a year ago.
do you still
Yeah, I
have
still
residual injuries?
Oh, yeah. It still bothers me.
Okay, have you seen other physicians or?
Yes, I seen my doctor and stuff, right, but I never really got into this, you know?
All right, has your doctor said anything to you about, an opinion as to why these injuries were caused or why they haven't healed?
Well, it didn't help. He said it didn't help breaking the ribs and stuff, you know? I had guys, people that came here to my house. I guess the hospital sent them or somebody sent them, my insurance. And the nurses told me, you should do something about this. Don't let them get away with
All
it.
right.
That's all I know.
There are two
so I don't know.
possible claims you might have. And what you really need to do is speak to a personal injury attorney and
Right.
or a medical malpractice attorney.
Right.
Here are the things. The fact that you had injuries there that occurred because nobody responded in a timely fashion when, you're hooked up to devices and it's very difficult to get out of bed. And I've had that same experience. I understand what you're talking about.
Right.
To me, that could very well be a negligence claim. And
Right.
so that the hospital would be responsible for the negligence which led to the injuries which you suffered. And that's a personal injury claim.
Right.
The part that may be possibly a medical malpractice claim is depending upon how you were treated and whether or not the treatment that was given was below the standard of care, and that led to you still feeling some of these injuries a year later. I mean, I don't know enough, but I would certainly say it merits talking to an attorney that specializes in medical malpractice. Now,
Right.
unfortunately, there are some attorneys that do PI, personal injury, and medical malpractice, but
Right.
for the most part, they're separate
Right.
because they're both specialties.
Right.
The first thing I would do is I would try to get a consultation with a
Right.
personal injury attorney.
Right.
And then the second thing I would do is, and that personal injury attorney might help you, might refer you, but I would try to get a consult with a medical malpractice attorney to see
Right.
whether or not you might really have a cause of action. But as
Right.
far as the personal injury, I think it's very likely that you have a negligence claim, and
Right.
very likely that you have a viable personal injury claim. And so I would certainly recommend that you talk to a personal injury attorney.
Right. I was trying to tell my wife the same thing.
Well, tell her to listen to the rebroadcast on WPSL.com when
Right.
they post it in a couple days, and maybe that'll persuade her.
The thing is, I never got better from this. Never.
and that's a shame. It really is.
It's terrible. I'm on oxygen now. And this is I can't explain it, but it destroyed me. It really did.
Well, I would definitely follow up first with a personal injury attorney, and then perhaps with a medical malpractice attorney. I think at a minimum you need to follow up to see whether they believe you have viable claims. If not, you can put it to bed. If they
Right.
do, and I suspect you at least have a personal injury claim,
Right.
that has some value there, they're much better able to value these things because they do
Right.
it all the time. But I definitely would not drop it and forget about it. And keep in mind, there are statutes of limitation, so don't just sit on it now. For example, with personal injury, you have a 4-year statute of limitations in Florida. Or for medical malpractice, now I'm not 100% certain, but I'm pretty sure it's 2.
Right. This has been a little over a year ago.
Okay. So I hope that helps.
All right, thank you. Yeah,
You're very welcome. Good luck,
Thank
and it's a really bad thing to happen in the hospital.
Thank you.
Take care.
Bye-bye.
Bye-bye. You know, it's unfortunate. I've been in a similar situation, you know. You go in for something, you're hooked up to goodness knows how many devices, and you got to go to the bathroom.
Right.
You know, and fortunately, most of the time when I've pressed the call button, I've gotten a relatively prompt response. There was one time, within the last year, that I decided, I'll head to the bathroom on my own and just pull along the pole that has me attached to everything. I did fine, but on my way back, I was caught. And they lectured me, don't do that again. Well, when you got to go, you got to go.
Yeah. And you guys aren't coming to help. So.
That's right. And that's unfortunately with staffing and depending upon the shift they're on, midnight to 8 or whatever, there isn't always a prompt response to the call button. Unless the machines are going off. Then usually somebody comes in, if for nothing else, to shut off the noise. But at least somebody's checking on you. And another good thing these days about a lot of the hospitals is they're able to look at the nurse's station at what the machines are saying in your room. So it's not, they don't even have to come into your room to see if it's a heart issue, blood pressure issue, something's going on with you. They can see it right there, and maybe sometimes that's why they come so slowly. But we all have other needs, not just the medical needs we go into the hospital for. All right, so that sort of also concludes our discussion about arbitration, unless anybody has questions. You're going to mediate a case. If you file a lawsuit, you're going to go to mediation, either early, voluntarily, to try to help settle it, or later on in the proceeding when the court directs you to go to arbitration. In Florida, they all do. It's a requirement. So you're going to mediation at some point. Arbitration, you can always pick with the other side. Sometimes there's good reasons to do that. Talk to your attorney. But arbitration also can be forced upon you if you've signed a document, let's say when you've applied for employment and they give you 100 pages to sign, and you're just signing, and sometimes I understand that, although it's not a great idea, but you're just willy-nilly signing everything. And lo and behold, when you go to want to sue them, they file a motion to dismiss because you signed an arbitration agreement.
But you're not about to tell your new employer that you'd like to have your attorney look over your papers.
No, not unless you're a higher level employee, and then it's sort of understood. But no, the average employee, let's be honest, signs what's presented to them. And that presents an interesting legal argument. When you sign something like that because you have no bargaining power, is it a contract of adhesion? And that's a legal doctrine which basically says you had no choice, there was nothing you could do about it, it's an unfair provision, should I as a court strike it? I will tell you, with regard to arbitration provisions, they are highly favored, and it's very hard to strike one unless you're able to show bias or something like that. And once the arbitrator enters his award, it gets confirmed in federal court or state court without much muss or fuss at all, unless, again, you have a real challenge to that decision. And the challenge can't be, the arbitrator, didn't follow the rules of evidence and allowed all this hearsay in. The arbitrator's allowed to do that if the arbitrator wants to do that. It has to be something along the lines of bias, prejudice, something more sinister. It does happen.
Like payment?
Yeah.
Okay.
Something like that. I didn't want to say it.
Yeah, well.
So other than that, that's mediation and arbitration. Now, before we move into what I think is maybe a 3-show arc on residential landlord-tenant because it is not as
Ooh,
simple.
I like that. I was a landlord a long, long time ago.
Then I'm not going to like you. Some landlords are good, but the ones I deal with,
Yeah,
not so much.
I was certified by the Texas Apartment Association, and I ran an apartment complex with 104 units.
Yeah.
Oh, could I tell you stories?
Did you change the plumbing when it needed to be changed?
Yes, we did.
All right.
Actually, my poor tenants had shredded curtains when we first took over, and I got everybody new curtains.
All
So
right,
I was
so
a
you
good
weren't a slumlorder,
No, I was trying to make it better. I had lived there. Wanted it
Well,
better.
I hear stories, and in Florida a lot, it's mold.
Okay.
And landlords
Yep.
who either won't take care of mold or put a little Clorox on it.
Yeah.
You know, and a quick tip before we even go into landlord-tenant. When it comes to mold, Florida law requires that mold be what's called remediated, which is a fancy word for fixed, by a certified mold remediation company. It's not the landlord. It's not the landlord's buddy.
The landlord's maintenance guy.
It's not Bill's Air Conditioning. It's a mold company.
Okay.
And if they use anybody else, then they're not doing what they're supposed to do. So let's see. I have a question that just came in.
Okay.
It didn't come in on line 1 or line 2. It came in from this kid to my right who
Has
really
a microphone.
really wish he'd get a haircut. But, well, Aaron, instead of me reading this, why don't you read it out loud to the listening audience? Get close to the microphone.
What if your employer says okay to you conferring with your lawyer, and then when you're ready to sign the papers, they won't let you because you left to talk to your lawyer?
Tough luck on you. Is that the answer you expected?
No.
No. All right. In Florida, it's a good question. Very good question. In Florida, you are generally an at-will employee. Unless you've already signed a contract that provides you can't be terminated except for cause. As an at-will employee, the employer can essentially do almost whatever they want to you.
Mm-hmm.
I mean, they could terminate you or take what's called adverse employment action for no reason at all, for a good reason, a bad reason, a fair reason, an unfair reason.
They don't need a reason, in other words.
No, that's right. They don't need a reason.
They really don't need a reason.
A factually correct or a factually incorrect reason. I've had cashiers terminated. Your drawer is short. Then the next morning, the employer found the money. It sounds like they should get the job back.
Mm-hmm.
Only if the employer wants to. There's no obligation, even though they were wrong. So you're an at-will employee. So what happens if you say, can I have my lawyer review these documents? And the employer says, sure, absolutely, no problem. And you come back and they say, never mind, we're not going to move forward with you. You're out of a job.
Mm-hmm.
I mean, you're out of a job you never had in the first place.
Right, because you didn't sign.
Right.
Okay.
Because now they're perceiving you as possibly a troublemaker down the road.
Yeah.
We have 2 calls, two questions, but...
And we have Doris on the line, so Doris,
okay,
hang
so
on.
before we go to the kid over here who has another question, let's go to Doris on line 1. Hi, Doris. How can I help you?
Hi. We were just wondering if you have to have like a private property or something like that, a sign posted on your property so that if somebody gets hurt, they can't sue you. Is that the law?
No, that's not the law. You can't put a sign on your property that is going to protect you from most types of injury. Now, there are exceptions. There are exceptions in every area of the law. It's possible you may be able to protect yourself from a negligence claim if you have proper warnings posted. You're not going to be able to protect yourself if the cause of action is reckless disregard, for the safety of others. So, for example, you don't happen to know there's this little indentation in your front lawn, and there's all these proper signs posted everywhere, and the UPS guy is walking up, and instead of walking up the driveway, he sort of goes to the left and knocks his foot into this little indentation and hurts himself. Well, I guess you might have been negligent. Have you protected yourself? Maybe. But if you knew that little indentation was there, then you may not have protected yourself because now instead of it being negligent, it may be reckless disregard. And that you cannot negotiate your way out of. Now, I will, even though you didn't ask, as a public service, tell everybody something which is very stupid, but is the law. It is the clear and unequivocal law in the state of Florida. and I haven't even done it yet, and I should have. If you have a dog, even the tiniest of tiniest of tiniest dogs, a sign that says beware of dog does not protect you. Does not protect you.
Wow.
Under Florida statute, which in my view is as stupid does, you must have a sign that says bad dog. You have to post a sign that says bad dog, and what does that give you? It gives you one free bite. You're laughing, right? And I'm laughing too. And it's true. If the sign is there and somebody, let's say, trespasses, and they're bitten, they're probably not going to have a claim. Now, the second time, depending upon whether or not you've taken any other remedial measures to protect against the situation, that bad dog sign may not work. The bad dog sign also does not work if somebody under the age of 7 is injured. So you have a fence, but it's not locked, and this 7-year-old wanders in, and the pit bull attacks, or the schnauzer attacks, or the poodle attacks. That won't protect you because the 7-year-old is incapable of understanding legally the bad dog sign. So I know that went beyond your question. I hope I did answer your question. And thank you for calling.
You're welcome.
Now, this other follow-up question, like in the what? Okay. In the press corps in the White House, they're always trying to sneak in these second and third questions.
Mm-hmm. Or their first question is a big run-on paragraph.
Well, yes, and we're going to divert again here now. I watch this stuff. Not always, but I watch this stuff. And there's a reason these days why they'll ask a question and they'll have their second and third questions in the first question. Because of late, press secretaries really don't answer the question. They don't even come close to answering the question. And so, the press it's their obligation to try to get at truth, particularly from sources of power, the government. And so they're really pushing sometimes, and I can see they irritate people like the press secretary or even the president.
Mm-hmm.
Now, I will not say that in prior administrations, you can go back 20, 30 years, that you don't have press secretaries that sometimes will evade questions. Sometimes they're doing it for nefarious reasons. Sometimes they're doing it because something's about to happen and it just simply cannot be disclosed
Right.
to the public.
Mm-hmm.
But for the most part, press secretaries try to have a relationship of trust with the press corps, because otherwise nobody's going to believe them. Things have gone downhill lately, so can't really respond to the press. We do have another question, but once again, we do have a call-in, so we'll take that as priority. Oh, my good friend, Bulldog. How are you, Bulldog?
Hold on.
Bulldog, are you there?
Yes, sir, I am.
How are you?
Oh, just fine, sir. Hey, well, I have a side question. So if I put a beware of dog, dog will bite sign in my front yard, I get one free bite, right?
No, you do not. You better change that sign to bad dog. And if you Google it, there are lots of signs that are pre-printed, bad dog, because they know about the Florida law.
So I get one free bite if I did that, right?
One free bite unless one free bite protects you from claims of negligence. It may not protect you from reckless actions that lead to the bite.
Oh, don't. Yeah, and bite is relative, sir. Anyway.
Right, and it won't protect you for a child under 7.
Well, no, I've got them. So. Yeah.
You've got the bad dog signs?
No, I got the grandkids.
Ah, okay.
Anyway, I did want to ask you a question, which may be, one of your specialties. But I wanted to ask you, and this is kind of part of research that I'm doing, is that how do you treat veterans or disabled veterans' rights in an employment workplace? I mean, how do you? I mean, I know there are cases about that, but what are really the guidelines for that?
Well, I would say for the most part, it falls within the Americans with Disabilities Act. And so if a disabled vet, let's say, has to remain seated, really can't stand, and the job that is being applied for requires standing, and that is an essential element of the job, then that disabled vet is not going to get the job and the employer is not going to have a problem. However, if they're applying for a job as a telemarketer, and so they're in a cubicle seated, but the requirement is that every hour they go into their boss's office and update them on the number of calls and whatever, I don't know. And they say, well, look, I need an accommodation because I really can't get up. So either I need somebody to bring it to you, or I need you to come to me, or I need it to be done at the end of the day. That is a request for a reasonable accommodation. And what happens under the ADA once a request is made for a reasonable accommodation is the employer now has an obligation to have a conference, could be informal, but a conference to review the request for the reasonable accommodation and to discuss whether or not to accept that requested accommodation or to come up with another type of accommodation which may also legally be deemed as reasonable. So they don't have to accept your suggestion, although they might, but if they come up with something that is equally reasonable and truly does accommodate you without substantially interfering with the employer's business practices or requiring them to do something that departs from the essential requirements of your job, then after that conference, they propose their resolution for a reasonable accommodation. And if it's reasonable, then they've done their job and they're immune from an ADA suit. If it's not reasonable, then that vet still has the potential to challenge it, with an ADA claim. So the ADA statute is really interesting in that there is a burden on the employee to make a request for a reasonable accommodation. And then there is a burden on the employer not just to review it and make a decision behind closed doors, but to have a conference to discuss it and then come to the employer's decision. And that leads a paper trail so that if one side or the other claims that it's not fair or not consistent with the ADA and it's challenged in court, there's a fairly good record as to what was asked and whether or not the accommodation sought or offered was reasonable.
Sir, yeah. May we take it a little higher plateau here?
Sure, you can be one of those law school professors that try to take me out on the branch until I fall.
Oh, I can try to do that. What I'm saying is there basically then are there because you know what my goal is, I'm sure. I'm helping VAs,
right.
Vets, right? And disabled vets need certain accommodations. However, job postings don't allow for a lot of that, and they don't say that, but they know that they're going to have to make special accommodations. And see, that can be a hiring turnoff. And so I'm trying to get around that hurdle to say, how can, these people re-entering the workforce, see, I think it's discrimination against the veterans to a slight degree.
You are undoubtedly right in many instances, unfortunately, which would be a violation of the ADA and maybe a violation, another Title VII violation for discrimination. I'd have to look to see if the veteran status is now a protected classification. I know there are a number of statutes that protect and assist veterans in seeking employment. But like any other Title VII claim, sometimes when it deals with getting the job in the first place, it is very hard to prove that any funny business went on when you are not offered the job. You may have a lot of suspicions, but without discovery, almost impossible to prove, unless somebody says something really stupid. Now, if you have enough and you file a lawsuit, then what the attorney is likely doing is seeking the records of all applicants for this particular position over the last 5 years and determining how many of them were vets, and were any vets hired, or were all the vets turned down, how many of them requested accommodations as part of their pre-employment interview. And now the attorney is looking to see, can I find a pattern of discrimination?
You just took away my thesis for my doctorate. Please.
Can I write the doctorate then?
You basically did right there. No, but see, that's my goal. And see, what I'm looking at is from your perspective is, do you see, that sort of, those sort of cases come up?
Yes, I do. I see it with vets, and I see it in all other types of, Title VII discrimination type situations. For example, it's against the law not to hire somebody because it's a woman. Proving that in the pre-employment context may be very tough, unless you have some evidence, so you have a basis to really file a lawsuit and then start seeking the records.
What if they only hire pretty women?
Well, that happens too.
All the rest of us have to scrounge around.
I'm gonna make sure I don't get in trouble. I would not say you qualify as the all the rest category.
No, I have.
But you're right. There are employers that only hire quote unquote pretty women.
Eye candy.
Okay, eye candy. I sued one of them about 2 years ago.
Yeah.
A business, I will not name the type, that is located on US 1 in Port St. Lucie. And, it ended up settling, but that was the allegation, that the women that were hired were all of certain characteristics, and that for that particular job, it was not an essential requirement of the job.
Yeah.
Now,
I had Hooters, Batman.
Okay, we're going to Hooters right now. We just had a little sign. We just had a little sign posted, held up in front of my eyes, by Cliff Desmond of Swap Shop fame.
Behave back there, Cliff.
Yeah.
And he says, "What about TNA?" And I will tell you, there is a substantial body of case law that says that there are certain types of environments where these rules are not strictly applied. So if you are it's called a TNA type business, so I don't want to offend anybody out there. If you are Hooters, there's a whole bunch of them. There's Tilt and Kilt and Boca. There's a whole bunch of different names now, a lot of copycats. If you're one of those types of environments and you only want to hire, women that have,
Well, let's just say women who can wear the costume.
Right, I was just going to say women who are buxom. But that is not necessarily against the law for that particular type of establishment.
Right. Because what
right.
You're supposed to fit the bill.
Now, then we go into the next step. Well, what about sexual harassment? And there is law there, too, that says what might be sexual harassment at Smith Barney may not be sexual harassment at Hooters. Because the employee comes in.
They call that ambiance.
Yeah. The employee does not give up their right to be free from sexual harassment. But the employee comes into that occupation, that job, understanding that there are certain things that are going to occur and that they're part of the job, and they simply can't be stopped. You can't stop a customer from asking you out on a date. You can't stop a customer from ogling you. Can you stop a customer from slapping you on the rear? Sure. You go to your manager, and that customer should perhaps either be warned or removed. Otherwise, maybe there will be a sexual harassment claim. But there are these establishments where the rules do get more liberalized, and the Supreme Court has even weighed in on that.
Bringing it back to the vets, though, is it a lot harder than to prove?
Well, it's a lot harder with the vets and with any other pre-employment category, whether it's gender or somebody says, I'm not being hired because I'm Haitian, and tells me they don't have any other Haitians working for them. Well, that helps me a little bit, okay? And so let's say I take the case and I file suit, and I get all these documents, and I see that in the last 5 years, only 3 Haitians have applied for a job.
Mm-hmm.
I don't have a good case.
Okay.
All right? But it is hard. Pre-employment claims, by definition, are harder to prove. It's that the person who's coming to you can't have as much information as you would like because they never had the job.
Mm-hmm, mm-hmm.
Now, they may have friends in there that can give them information. That's always helpful. But yes, veterans not getting a job, harder to prove. It does happen. You know, unfortunately, there are companies, there are good companies. I deal with the bad ones. But there are good companies that, you know, give preferences to a vet. And, you know, I just think that, you know, I've represented a number of vets. I just concluded a very short representation of a vet who, I think I mentioned it either last week or the week before, who was turned away at a doctor's office with his service animal, who was properly certified and trained because the doctor did not want a large dog in the reception area. Well, they've paid him a little bit of money right now. And that's a violation of a federal statute. And it happens. Now, he happened to be a vet. It could happen to somebody else who, you know, somebody who was raped and has PTSD and needs an animal to help them in certain situations. You know, it doesn't have to be a vet. But since we are on the question of vets, absolutely it happens. And, you know, it's funny. My family is not a family that really has a military background. I think my father was in, I always forget, it wasn't the Coast Guard, it was a Merchant Marine. And he had a stripe removed when he punched his commanding officer in the face one day.
That doesn't go over
He's
very
deceased,
big,
so I
does
can
it?
say that. They removed a stripe and made him peel potatoes.
Mm-hmm.
I was never in the military. I don't know really of anybody else in my family background that served in the military. But somehow, ingrained in me, has been a tremendous. Oh, I am so sorry about John. John, I'm gonna get you in just 1 second. I apologize. Somehow, it's been ingrained in me. This veterans deserve respect. They deserve the little added extra, you know, for having served overseas. Particularly these days, man, when they're serving and, you know, any moment they could lose their life. They deserve something extra when they come back here, and they deserve to be taken care of. And I get pretty peeved when somebody doesn't. John, you're on line 2. How can I help you? And I apologize for making you wait.
Good morning. I was a younger man when I first called you.
Yeah, you probably have a beard now.
Before I ask you my question, I wanted to tell you a little brief story
Sure.
that Bulldog brought to mind with his first question. A traveling salesman going through Maine stopped at a general store, and there was an old-timer sitting on the stoop with a great big dog alongside of him. And he said to the old man, he said, "Does your dog bite?" And the old man said, "Nope." So he reached over to bite the dog, and the dog bit him. He said to the guy, "I thought you said your dog don't bite." He said, "He ain't my dog."
Very good. That means you got to ask a lot of proper questions to make sure you get it all done.
Here's the question.
Okay.
Is there a statute of limitation on medical malpractice?
Yes, absolutely. In Florida,
Yeah,
it's 2 years.
So I'm out of luck, huh? Well, I'll
Well,
tell you
okay,
that.
now before we say you're out of luck, because remember what I said, almost everything has exceptions.
Yeah. Well,
Generally,
here's the thing.
it's 2 years, but it all depends upon when you discovered that you may have been the victim of
Well, you know what? I realized it later that I probably had it, you know, what do you call it? A valuable. What do you call
a
it?
viable claim.
A viable claim.
And is that still more than 2 years ago?
Yeah. Oh, yeah. Much longer. I'm not a let's sue him person. you
Yeah.
know? And what happened was I had open heart surgery in 2000. A group in Stuart I went to Mount Memorial, and one of the cardiologists from a Stuart group discovered 2 blocked arteries with a heart catheter. So they shipped me down to Palm Beach Gardens, and 3 weeks after the double bypass, I was extremely tired all of a sudden. I could hardly walk across the room.
Right.
And I kept calling the office, and they kept putting me off. Oh, he'll call you back in the afternoon, and they never did. So on the 4th day, when I called, they let me speak to a nurse or somebody in charge, the office manager, and she told me that they're not going to see me because I didn't have insurance, and if I wanted to come in and see the cardiologist, I'd have to have cash. But by that time, I had had a heart attack. So I went back into the hospital, and they shipped me back to Palm Beach, and they were able to open up one of the arteries with a stent, and they couldn't save the other. And it's been kind of downhill. Unfortunately, my cardiologist has a machine that compresses your legs, and it helps grow new branches.
Right.
And that's helped over the years. But the thing is, I think later on that I couldn't sue the hospital because I probably couldn't prove intent, that he did it on purpose.
Well, that doesn't have to be on purpose, but at this point, the real question is the timing.
Well, I think I should have been able to sue the cardiologist's office for not directing me to go to emergency or calling me back for 4 days. And then she admitted to me it was because I didn't have money.
Right. And that was all more than 2 years ago.
Yeah, it was back in 2000.
Oh, goodness. Yeah, unfortunately, I hate to tell you, you're going to be barred by the statute of limitations.
Yeah, I'm not looking to sue. I just, I didn't
But you're
know,
right, you shouldn't have been treated that way. Nobody should be treated that way.
Which one do you think was more likely to...
I honestly can't tell because I don't know if what happened to you was a result of the original surgery, and even if so, was it the result of an error being made or the surgeon acting below the standard of care?
What about the cardiologist not wanting to see me? But
well, that's a problem. I don't know if that's going to lead to a malpractice claim, but again, whenever it comes to these types of medical things, the documents are what's key, and without the documents...
I wanted to ask you a question.
Sure.
In your experience, have you ever... I don't know if you handle these types of cases, but sometimes when you go into surgery, I wonder if it's the actual surgeon that is doing the surgery or an assistant or somebody,
Well, it's depending upon the surgery, it's usually a combination.
Yeah.
And you find that out from the surgical records.
I've had 2 surgeries in my life, and they were both botched.
That's unfortunate.
A few years ago, I went in for lap band surgery, and when they were trying to snake the band around the stomach, they tore a hole in my stomach wall, and they had to take the band out and send me home, And when I saw the doctor a week later, he said to me, I said, what happened? Why did that happen? And he said, well, there have been studies that say that obese men have thin stomach lining because they eat more carbs than protein.
Well, and that's the people who get the lap band surgery or the gastric bypass. So
No, this is the surgeon. Yeah, well, this is the surgeon telling me this,
right.
And he said, so I said to him, well, if you know that, why don't you put an obese man on a high protein diet for 6 months before you do the surgery?
I hear you.
And his answer was, well, the studies are inconclusive.
Yeah.
I think he should have run for office.
Well, John, I thank you for calling. I'm sorry you really can't do anything at this point, but
I thank you very much.
You're welcome. Gina, are you still on line 3?
Yes, I am.
Thank you for calling. Thank you for holding. How can I help you?
I had a windshield replaced on my car.
Yep.
And it leaked and ruined the motherboard on the car.
Hey.
Is there, and they actually came out and replaced the windshield, but the motherboard went out over time as the water got down to it. Are they responsible for that?
All right. If the motherboard was damaged, not as a result of the crack in the original windshield, but as a result of the way they put in the replacement windshield, yes, they are responsible for it.
Okay, because they kind of admitted to it, and now they're just kind of giving the runaround.
How much will it cost you to fix everything?
$1,000.
Okay, so you're in the small claims court realm.
Okay.
If you have a mechanic or a dealership who has fixed it, and you have a receipt shows how much you've paid, and if there's something, if they could put something down that says, this was caused, because water was intruded into a replacement windshield, then you may have a good chance in small claims court. And
Okay.
small claims court is relatively simple. You can get a packet from the clerk's office. Almost anybody can fill out those materials on their own. And the very first thing they do when you go to your first appearance is they send you to mediation. And hopefully it gets resolved there. And most people don't even use an attorney for that.
Okay, I appreciate that.
You're welcome. Take care, Gina. Good luck.
Thank you. Have a great day. Thanks.
All right. Well, folks, we are almost out of time. We've had, let's see, looks like we've had 6 calls, a question from the kid to the right, another question pending from the kid to the right, which from Cliff Desmond, which we probably won't get to. But look, I thank you for the calls. I thank you for the fact that you didn't let me get into landlord-tenant today.
But I can't wait.
So we will plan on starting that next week, and if you all have enough calls and we don't get there, that's okay too, because what's on your mind is really what we're doing here on the show, and my little outlines are designed to fill in the time and give you all some information on areas that I think may be relevant to a good portion of the listening audience. But I don't mind departing from it at all. So we will quickly take a quick look at this last question. Can a landlord be held liable if his employee, including bookkeepers, are committing acts of fraud against his tenants? Yes. If the landlord has any reason to know it's occurring, or has been advised previously and has permitted the employee to remain in that same position to continue perpetuating the fraud, they're going to be potentially responsible under what's called a respondeat superior doctrine. And all that means is the employer is responsible for a variety of acts committed by the employee, as this goes back to way back in England, as the master of the employee. So
It starts at the top, right?
Right. We don't usually call them masters anymore, but go back to 1762 and the court of the king of the queen's bench, and that's what it's called.
It's kind of the same. It's just more polite.
All right, we are just about ready to conclude today. I hope you all have a very good weekend. I thank you for calling. I thank you for listening. If you need to call my office, it is 772-781-8003, and we will have a very friendly Cheryl there, my paralegal, to take your call, to get some basic information from you, and then to come in and chat with me to see if there's anything we might be able to do for you, or to get any additional information, or to bring you in to the office. So give Cheryl a call. We all know she has nothing else to do. I don't give her any work to do, so she needs your calls. Otherwise, call us next week on Ask a Lawyer, 10:05 a.m. on Fridays, 340-1590. And folks, thank you, and have a wonderful weekend. Bye-bye.
This is WPSL Port St. Lucie, the talk of the Treasure Coast.